We had a big court decision in the New York, the ongoing saga of the New York gun carry regime. That's seems like, every few weeks there's more big news. But you wrote a piece about actually a pretty major ruling in the case where a injunction was finally issued. If you want to tell us a little bit about what happened there.
Yeah, that's right. The Northern District case. This was Judge Sotheby, who we've talked about a number of times in the past, because that case has been particularly interesting in this whole fight over New York's new gun carry law, their response to the Supreme Court striking down their old gun carry law. And now, of course, it's been preliminary and it's been enjoined. There's a preliminary injunction issued against the law by Judge Sotheby, which blocks most of the controversial provisions, not every single one, but it does block the vast majority of them. For instance, a lot of the requirements attached to obtaining a permit were enjoined. So you don't have to give the information, your family members' information to the police, which was a requirement. You don't have to turn over your social media accounts. You don't have to prove that you have a good moral character, or at least the state can't deny you a permit based on their subjective judgment that you don't have a good moral character, because he found that was basically identical to the good reason clause that the Supreme Court struck down in their ruling in New York State Rifle and Pistol Association v. Bruin. So the bunch of the requirements for how you obtain a permit are now blocked. And then he blocked a number of the sensitive places restrictions that the state tried to put in place. So, for instance, it's a pretty long list because New York had kind of tried to ban gun carry almost everywhere in the state, right? But he blocked the ones that pertain to restaurants that serve alcohol. So this is even if you're not drinking any alcohol, they barred you from carrying in a restaurant that serves alcohol, which actually is not a completely unique provision for New York. That one, this might actually have some relevance in other states where they have that same policy. Some states do prevent you from going into. There's a couple different approaches to that. Like Virginia, where I am, you can carry in a place that serves alcohol. You just can't drink alcohol, obviously, while you're carrying. But there are states that have this same policy, and then there's some that have a policy against carrying in places where their revenue is more than 50% from alcohol, which is meant to obviously target like bars and things. So it'll be interesting to see if that spreads to other restrictions in other states that have less restrictive gun laws. But there was a provision against carrying in a theater, at protests, places of worship. Even if places of worship was a total ban, even if the church or synagogue wanted to allow you to carry, you couldn't. Banquet halls, conference centers, parks, areas at airports or clinics that are before security. A lot of states will allow you to carry up to the security area at an airport if you have a permit. Again, these are all things that apply to people who have permits, who've gone through the process to get a permit. They still would have been off limits in places like this. And then also public buses. However, and one of the bigger ones, one of the ones with the most consequential implications was this provision that blocked people from, by default, from carrying on private property, even at businesses that are open to the public. So it kind of flipped everything on its head as far as the way most states handle this, because in every other state, essentially, you can carry as long as there is not a sign posted that says you can't carry. But New York made it so that you cannot carry anywhere unless there's a sign posted that says you can carry. And Sotheby struck that one down as well. He did uphold a number of provisions, or at least not block a number of provisions, even some that he had previously blocked. So the entire area of Times Square being off limits to
loosely
gun carry.
defined, area.
This vague, like they made Times Square this giant section around the intersection that everybody knows as Times Square off limits, and this injunction doesn't block that. Same for the subway, even though it blocks the gun-free zone on public buses, it doesn't do so for the subway system. And these largely came down to lack of standing. Sotheby has been a real stickler for standing. And so he determined in this ruling that the plaintiffs didn't have standing for a couple of these things. He actually had a couple footnotes in those areas where he essentially said he would block these provisions if the plaintiffs could prove standing. So essentially, it seems like they probably have to bring another lawsuit for each of those other provisions, the couple that are left over after this. So, ultimately, it's a pretty big win for gun rights advocates. This was a case from Gun Owners of America, and they've had a long go of it because initially Sotheby tossed their first lawsuit altogether over lack of standing because he didn't like the way that they had pleaded it and how their plaintiffs had given answers in questioning. So they had to refile the case, and then they went through the temporary restraining order, which they got but was stayed, and then now they got this preliminary injunction, which is not stayed. That's another key point. This went into effect immediately, and New York has been barred from enforcing these things, at least until perhaps the Second Circuit intervenes and they file an appeal.
Right. And I have seen New York has since filed the notice of appeal with the Second Circuit in this case. But like you said, the key difference here is this time Sotheby said this is not stayed pending appeal. So this injunction will take effect. So that's a bigger win for, I think, gun rights advocates in New York, because as you pointed out with the last TRO, he delayed it 3 days, and then New York immediately appealed, and then the Second Circuit put another stay on it without actually addressing the appeal, and it's just been sort of hanging in limbo. So not much of a emergency relief order there if it's just going to be stayed while judges sit on it for a while. But as you pointed out, big difference here: the injunction actually goes into effect, and it will stay in effect until otherwise noted by an appeals court.
And you would expect that the Second Circuit will put a stay on it,
probably,
and accept this case at some point here in the near future. So, that's something to keep in mind. This isn't the fight's not over here for either side. The Attorney General gave us comment for the story, just said that they're looking at their options for moving forward, and there's no reason to think that they're not going to fight this up at the Second Circuit. Although I feel even if they win in the Second Circuit, it'd be hard for me to imagine the Supreme Court not taking this case, because it directly contradicts what they ruled in Bruin.
Right.
So I think they'd be pretty eager to step in and do something if this law did make it through scrutiny at the Second Circuit, which we'll certainly be watching for and reporting on for all of you guys. But there's another question at play here when it comes to the stay and enforcement of this injunction, and that has to do with New York City which is in the Southern District in New York. So this is a case in the Northern District. Then there's a case in the Western District, which also which dealt specifically with the places of worship prohibition. I believe that's a Second Amendment Foundation case, and the judge there put a temporary restraining order in place basically immediately. And so with no stay, which means New York's been enjoined from enforcing that part of the provision. But New York has taken a very specific approach to these rulings and is really only abiding by them in the specific districts where they've been issued. So the Southern District of New York where there is also a lawsuit against the places of worship prohibition that's filed by a Jewish group down there. They have been enforcing this law despite those other orders from the Northern and Western District. And so the Southern District judge he denied a temporary restraining order request and hasn't moved very quickly on the preliminary injunction hearing. So that one is still in limbo and it's still not clear. And the Attorney General's office did not answer my question when I asked whether they would continue to enforce this law outside of the Northern District. But in court, they've argued that they're entitled to do that. So this ruling may not have an effect on the entirety of New York State.